And is a, thank you, thank you. So we have Ms. Krafthofer on behalf of the objector, and Mr. Stafford Owens, are you here? Mr. Stafford Owens, are you here? Okay, so let the record reflect that Mr. Stafford Owens is not in attendance today. Is there an attorney here representing Mr. Stafford Owens? But the record also reflect that there is no attorney here representing Mr. Stafford Owens. At this time, just for the sake of creating a complete record, just wanted to read some things into the record. First, there was a request by the candidate to file a late motion to strike and dismiss. However, I had stated that that is not a ruling that I make. That is a ruling that the board makes as to whether to accept such a late filing, but he never actually filed anything. There was also a records examination that was conducted on Friday, December 13th, and I will read the results of the records examination into the record. The total number of signatures required for this office is 657 signatures. The candidate submitted 78 pages with a total of 735 signatures. There were a total number of objections or signatures objected to was 619 signatures. The total lines sustained at the records examination was 306. The lines overruled was 45. The candidate reserved 3 signatures for review. The objector reserved 90 signatures for review. The total number of valid signatures was determined to be 429 signatures. The total number of unchallenged signatures was determined to be 384 signatures. After the conclusion of the records examination, which was on 12/13/2024 at approximately 11:03 a.m. and 40 seconds, the candidate was determined to have 228 signatures fewer than the required minimum. Under the rules adopted by the board at the previous meeting, both parties were allowed to file what is called a Rule 7 motion, but that Rule 7 motion was required to be filed in most other electoral boards. It's commonly referred to as a Rule 8 motion, but for the purposes of this board, it's a Rule 7 motion. There was, again, both parties are given leave to file those motions under the rules up to 48 hours or within 48 hours of the conclusion of the records examination. So that would have meant that they had until December 15th, 2024 at 11:03 a.m. and 40 seconds. There were no Rule 7 motions filed with our office. And according to the rules, anything that gets filed is supposed to be filed with the electoral board attorney at my address. Again, there was nothing done by the parties. There was no Rule 8 or Rule 7 rather filed by the candidate or the objector. So at this time, it is my opinion that the result of the records examination should stand, and I would ask for a motion to accept the results of the records examination into the record.
So moved.
Okay, so we have a motion by member Wells, a second by member Gray Everett to accept the records examination results into the record. Chair Gonzalez.
Yes.
Member Wells.
Yes.
Member Gray Everett. Motion carries. The next order of business would to be a motion to sustain the objections as presented, because as of the conclusion of the records examination, and again, no other motions were filed, the candidate was deemed to be 228 signatures below the minimum. So I will need a motion to sustain the objector's petition and to order that the candidate's name not appear on ballot.
Sir.
Okay, so I have a motion by member Darlene Gray Everett and a second by member Chris Gonzalez. I will take a roll call now. Chair Gonzalez.
Yes.
Member Wells.
Yes.
Member Gray Everett. Okay, so as stated in the prior hearing, we will draft a written order as required by the election code. We will tender a copy of the written order at the next electoral board meeting, which we will set the date and time for soon, once we all can talk about our calendars and figure out amongst all the parties which dates work. And at that time, we will again tender a written copy of the decision. So I would ask objectors counsel, do you waive in-person service, statutory service, with the caveat that of course you will get an email copy of the written decision. Okay, thank you. And as candidates or candidates counsel are not here, I do believe we have his email address on file. We will still send him a written copy of the decision. There's no further business as it relates to this case. Okay, thank you. All right, so we will be calling, the next case, for the rest of them, I'm just gonna call them in order. Oh, you know what, yeah, let's do that one really quick too. We have other objections against Mr. Owens. So let's just call those and dispose of those really quickly. So the case number that we have for this one is 07. This is 25 TOEB suit 07, Valeria Stubs versus Stafford Owens. And again, I will make a call to see if Mr. Owens or his attorney is here. Okay, we do not have Mr. Owens here. Counsel for the objector, could you please state and spell your name for the record?
My name is David Avery. My name is spelled as follows: first name David, last name.
Thank you very much, Mr. Avery. At this time, just like in the other case, there was a records examination conducted based upon signature objections presented by the objector. So I will read those I will read the findings of the records examination into the record. This records examination for the record was concluded on December 13th, 2024 at 10:57 a.m. Under this records examination, again, the signature requirement is still 657 signatures. There were a total of 78 pages with 738 signatures submitted. There was a total of 422 objections lodged against the candidate's nomination papers. 422 were ruled upon. 111 were sustained and 91 were overruled. There were 0 reserved for review by the candidate and 0 reserved for review by the objector. The total number of valid signatures was determined to be 627. Total number of unchallenged signatures was determined to be 536. As of the conclusion of the records examination result, the candidate was deemed to have 30 signatures fewer than the required statutory minimum. Just like in the other case, there were no Rule 7 motions that were filed by either party. So at this time, I would ask the board to make a motion to accept the results of the records examination. Okay, so I have a motion by member Loretta Wells, a second by Chair Gonzalez to accept the results of the records examination. I will call roll now. Chair Gonzalez?
Yes.
Member Wells?
Yes.
Member Graham? Okay, the results of the records examination have been accepted into the record. Now, at this time, I would ask for a motion to sustain the objections by Ms. Valeria Stubbs against Mr. Stafford Owens, and to order that the candidate's name not be printed on there.
Second.
So I have a motion by Chair Chris Gonzalez, a second by member Loretta Wells to sustain the objector's petition against Mr. Owens and to not print Mr. Owens' name on the ballot. Chair Gonzalez.
Yes.
Member Wells.
Yes.
Member Graham. Motion carries. And just like in the other case, we will draft a written decision that will be tendered to the parties in open session at the next hearing. Mr. Avery, if you would like to waive statutory service and we can serve you via email, that is your prerogative. What would you like to do? Great, thank you. All right, so that concludes this matter. All right, so at this time, there were no other cases that we were double checking, but I don't believe there was any other cases with signature examinations. The rest of the cases involved legal issues. And Mr. Quigley, I do understand that you also have an objection against Mr. Owens. When we call your case, it'll be up to you whether you want to proceed with the objection or withdraw, that's up to you. Obviously, you saw what just happened in these other two cases, that's completely up to you, but I don't believe you have a signature objection, would that be correct? Okay, and just for the record, that is, Demarcus Crigley, that was just speaking with DE, capital MARKUSCRIGG. Those for the benefit of the court reporter, everybody. All right, so we're gonna call the rest of the cases in order, because there's obviously more cases that we gotta get to after this. So the next case we are going to call is case number 25-202, which is Keith Price and Michael Smith versus Nathaniel Shield.
Good morning.
Good morning. I would ask the parties both state and spell your name for the record. Let me ask the court reporter, do you need Mr. Price and Mr. Smith to do it again? No, okay. So Mr. Fields, if you could state and spell your name for the record.
Nate Fields, NATEFIELDS.
Okay, and you are the candidate, correct?
Yes.
And for the objectors?
Michael Smith.
Okay, thank you very much. So on this case, if the board recalls, we set a briefing schedule that required all briefs to be filed by December 9th at 5 p.m., replies to be filed by December 11th at 5 p.m. I'm sorry, responses to be filed by December 11th at 5 p.m. and replies to be filed by December 12th, with the hearing set today. In order to expedite these matters, it would be my suggestion to the board, and this would be for all cases, that the board institute a 10-minute limit on oral argument for both parties and the movement of the motion. So whoever filed the motion would be able to split their time up if they wanted to. If they wanted to have 7 minutes on their presentation and 3 minutes on reply or rebuttal, they could certainly do that. Would that be something that the board would like to do in order to expedite these matters? And if the parties need more time, they can always ask the board for more time, and that would be up to the board, but just for the sake of expediting these cases, it is a very long call. So would the board like to do that? Okay, so then I would ask for a motion to institute a 10-minute time limit for oral argument for all cases to be heard.
So.
Second.
This one we can just do all in favor, any opposed? Okay, motion carries. So with that, I'm just going to give a little procedural history. As I see, and obviously the parties are welcome to dispute the procedural history in their oral argument. So the electoral board rules do require that motions do be sent to me, and my understanding with Mr. Field, you did not send it to me, you actually filed it with the clerk. So technically that's not compliant with the rules. Obviously, the other side may have some issues with that, so they're going to make their statements, I'm sure, but just wanted to, and I guess, put that out there. And so you did file something, in fact, and then that was sent over to the objectors once we realized the filing, and it was sent over, I think, maybe a day or two later. So the objectors, if memory serves me correct, and please correct me if I am wrong, I believe the objectors did not file a written response in this.
No, we're gonna stand on our objection.
Okay, I just wanted to make sure that the record was clear. Okay, so then at this time, I think it'd be appropriate to begin the oral arguments, and you'll take care of the timer? Okay. And my colleague Hannah will take care of the timer for us. And if you could, when we're getting close to like the 2-minute warning, 2 minute, 1 minute, just to make sure that the parties realize where they're at. And before we begin oral argument, does the board have any questions on the procedure? Okay, all right, thank you. Mr. Fields, you can go ahead and start presenting your case.
Okay, so, I did file with the clerk's office that response, and the clerk's assistant did notify me and say that she would email that filing to you. I know that the code report said that I was supposed to file, but they're letting me know that she would send it to you. To me, in good faith, felt like it would make it any time into you. But as far as the objections, Keith Price and Michael Smith filed objections to myself on November 25th. The objections alleged the failure to file a statement of economic interest and failure to identify the office sought. Now, the second claim was voting the ballot of an established party during the previous election primary ballot. Number 3, petitions not bound properly. 4, the statement of candidacy of political party affiliation absent. Now, number 1, failure to file a statement of economic interest. Under section 10.5 of the Illinois Election Code, candidates are required to submit receipts for the appropriate office, verifying that their statement of economic interest was filed. I complied with this requirement by filing the statement of economic interest with the Cook County Clerk before the statutory deadline. Now, submitting the stamped receipt from the Cook County Clerk as well to the Thornton Township Clerk's office along with my nomination papers. I also included that receipt as my proof. While the receipt does not explicitly state that the office of this omission does not invalidate my candidacy, the receipt's sole purpose is to confirm that the statement of economic interest was filed with the appropriate office, which it is. The statement of economic interest itself includes all required information, including the office of, as mandated by Section 4A1-104 of the Illinois Governmental Ethics Act. Thus, there is no ambiguity about my candidacy or the office for which I am running. Now, the omission of the office sought on the receipt is a minor clerical defect that does not impact the validity of the receipt or my compliance with the election code. To further demonstrate my transparency and accountability, I also filed an additional notarized statement of economic interest with the Thornton Township Clerk's office. While not legally required, this statement of economic interest includes all necessary information, including the office sought, reinforcing my good faith effort to comply with all legal and ethical requirements. Number 2, the non-participation in party primaries. The objector alleges the issues regarding my candidacy based on Section 7-43F of the Illinois Election Code, which applies only to individuals who vote in primary, party primary, and then attempt to run as an independent candidate. I did not vote in the primary election of any established party. Therefore, this section does not apply to me, and there is no legal basis for disqualifying my candidacy on these grounds. Number 3, independent candidate status and statement of candidacy. The objector claims that my statement of candidacy does not explicitly state that I'm running as an independent candidate. While this language was omitted from the subsequent statement of candidacy due to clerical oversight, my intent has always been clear. On October 21st, I filed nomination papers, including a statement of candidacy, explicitly identifying myself as an independent candidate. These papers remain on file with the election authority and have not been withdrawn. I've included that proof. Section 7-10 of the Election Code requires candidates state their party affiliation if applicable, or if running independent, include a statement that they are not affiliated with any political party. While the subsequent filing was omitted, this explicit language, Illinois election law recognizes the principle of substantial compliance. The totality of my filings demonstrate my clear intent to run as an independent candidate, eliminating any potential confusion amongst voters or elected officials. The omission of the subsequent statement of candidacy is a minor technical defect that does not affect the sufficiency of my nomination papers or the integrity of the electoral process. Now, to resolve any procedural concerns, I respectfully request the opportunity to amend the statement of candidacy to explicitly state that I'm running as an independent candidate in compliance with Section 7-10. Now, as far as the proper binding of petition, the objectors allege issues regarding the binding of my petition. However, my petitions were properly bound at the time of filing. The petitions were neatly fastened together in book form, secured at one edge and numbered consecutively. This compliance is evident in the scanned documents provided by the election authority. The petitions meet all requirements under Illinois Election Code, and there is no valid basis for disqualification on these grounds. Now, the objections raised by Keith Price and Michael Smith failed to demonstrate any material or substantial defect in my nomination papers that would disqualify my candidacy under Illinois law. All requirements of the election code have been met, and any minor technical errors do not impact the validity of my filings or the clarity of my candidacy as an independent candidate. For these reasons, I respectfully request that the Electoral Board strike the objections in their entirety, 2, allow my candidacy to proceed, and 3, grant such other and further relief as the Electoral Board deems.
Okay, thank you. 4 more minutes left. All right, the 4 more minutes left on rebuttal, should you so choose to use it after the objectors state their case. All right, objectors.
First thing we're going to attack is the motion to strike and dismiss. According to the rules of the Electoral Board, and I'm pointing out rule number 9, filing and service of documents. Unless otherwise specified by these rules or permitted by the order of the Electoral Board, all documents filed by a party in connection with the proceedings on objection shall be filed with the Electoral Board's attorney in person during the proceeding of the Electoral Board. In person at the Electoral Board's attorney's office, which is located at Delgado Law Group, LLC, 1441 South Harlem Avenue, Berwyn, Illinois, 60402, by fast mail, 708-222-7001, or by email. All documents filed by a party in connections with the proceedings shall be served by the filing party upon every other party to the proceedings in a manner reasonably calculated to provide actual and prompt notice to that party. Each document filed with the Electoral Board's attorney in connection with the proceedings shall also include the filing party's written certificate setting forth the time, date, and matter in which the document was served on all other parties. If the party has considered to service by fast mail or email, service may be made by that party via fast mail or email. 2 things I want to note. When you talk about a motion to strike and dismiss, the law states there are 2 prominent things that must be in that. Number 1 is a proof of service. We have no proof of service in this document. Number 2 is the notice of filing. Based on those things alone, this document should be overruled, should not be accepted by this Electoral Board. It does not show a proof of service nor a notice of filing. And that's in accordance to the Illinois State Board of Elections code. It was not emailed to us as a party. All right, that's on that. To talk about the objection in itself, as the candidate alleges in his motion to strike, he puts forth the evidence that he did not file a statement of candidacy, a statement of economic interest, which lists the office which he is seeking, which is Township Supervisor. That is in his packet labeled as Exhibit A. This is a fatal flaw in accordance with the election code. And it states, inclusion of the office sought is made mandatory by Section 10-5 of the election code, which provides that all nomination papers are invalid if a candidate fails to file a statement in relation to his candidacy. Candidate statement of economic interest which fails to list the government unit invalidated the nomination papers. That's Fortis versus Washington, 87 EB ALD 56, Chicago Electoral Board 1987, White versus Thomas, 87 EB ALD 126, Chicago Electoral Board 1987. In regards to the other statement of economic interest, the candidate submitted 2 statement of economic interest, neither of which are valid. One does not have an official stamp from the Cook County Clerk's office in its notarization. The other statement of economic interest does not provide the office sought, which is required by 10-5 of the election code. All right. Our next alleged by the candidate in his statement is candidate's statement of candidacy wasn't binded to the rest of his petition packet. This notice was reviewed when we reviewed the original petition packet in the clerk's office. Statement of candidacy, statement of political party affiliation absent. Section 7-10 of the election code provides, among other things, that a statement of candidacy shall state that the candidate is a qualified primary voter of the party to which the petition relates, referred to herein as the party affiliation statement. Candidate failed to properly bind petition packet should or make the statement of candidacy stand alone. And in doing so, it violates said section of the election code by not listing his party affiliation statement or none thereof. So I'm asking for this electoral board two things. Number one, that the candidate's name not appear on the ballot based on the fact of rule of law, that the candidate failed to file a stamped copy of a statement of economic interest with the office. And then the other thing is that the candidate failed to list the office in which he's seeking on his statement of candidacy. And I'm asking also that the electoral board overrule the motion to strike and dismiss for not properly being filed, as well as not having a proof of service and a notice of file.
Is that all for the objectors?
Yes.
Okay, thank you. All right, at this time, Mr. Fields, you have an opportunity to respond.
Okay, the objectors claim that I didn't file the statement of economic interest correctly. And then they add on, I didn't include the office saw. But the fatal flaw is not filing my statement of economic interest. That's filed. You said it wasn't stamped. It's stamped by Markham Courthouse. And also filed with my petitions. Every other document implies, even the ones I filed prior to, said that I'm running as an independent candidate. And everyone knows that I'm running for Thornton Township supervisor. There's no mistake, no mistakes made. Everything I did was in good standing. I went and got petition signatures twice. I got them all by myself. I mean, I'm doing this thing the right way, and we still got people that want to try to stop, you know, but it's expected. Another thing was that I did not bind my petition. You guys said you saw my petitions in the office. What office did you read my petition?
Mr. Fields, it's time to argue the arguments should be directed towards us.
Oh,
not
I'm
to-
so sorry.
It's okay,
I'm so
it's okay.
Okay, the objectors claim that I did not file my petitions correctly. They bound it correctly. They were bounded. They were numbered consecutively. And I did follow the guidelines within the Illinois election code. I think that the objectors might have saw my petitions after they were taken apart and scanned, and then they assumed that all the documents were binding together. But they claim they went through them on their own with their hands. But my thing is that I saw petition sheets through a scanned document. I'm trying to see how they saw my petition sheet. Was it taken apart and did they come down to the office and see it taken apart and scanned in physical copies? But that is my argument, that how they saw it. I turned them in scan binding. It might have got taken apart in the scanning process. I know they have to be taken apart in the scanning process unless they're all scanned in and get the vision. Now, as far as filing the response, I'm sorry.
Just about 20 seconds.
Okay, so yeah, I did file with the county clerk. I mean, with the authority, the election authority, in the clerk's office, and then she did notify me that she would send that filing to you, and that's what I still did that in good faith.
Okay. All right, so at this time, both parties have presented their arguments. The first order of business would be for,
Don't, did you say we have a rebuttal as well?
no, they're the movement. The movement gets the last word. That's why I said if you guys have anything more, if the board wants to entertain additional statements from you, the board. Does the board have any objection? No, okay, go ahead.
All right, so, thank you, Honorable Board. I want to just direct your attention to the actual objections on number one. It clearly says failure to identify office salt and failure to properly stamp, to have a proper stamp on statement of economic interest. So for the candidate to throw out that we just added this at the last second, that's not true. It was on the original objection. Furthermore, when we reviewed, well, when I personally reviewed the petitions in the clerk's office, after looking through all the petitions, I noticed that the one particular, wasn't bonded properly to the, rest of the petition packet. I asked the assistants in the clerk office, is this how it was turned in? She said, yes. You can clearly see that that one document that I do refer to in the challenge will not have any holes in the top as if it was bound with the rest of them. So, I mean, we stand on the rule of law from the election code, and you can also look at the actual petitions for yourselves.
Okay. All right, does that conclude oral argument? Okay, thank you. So the first order of business before the board would be to determine whether it wants to accept the filing from Mr. Fields that did not technically comply with Rule 9 of the Electoral Board's rules. Now, if the board chooses not to accept the filing, that just means that that document does not go into the record. Obviously, the parties still argued their case, so you would still make a decision on the merits. So it's really up to the board whether the board wants to accept late filings or filings that, and not late filings, since this filing was actually timely, it's just not technically in accordance with the manner in which the filing was supposed to occur, which was to be filed with me with copies to the opposing parties. And the only way that the opposing parties actually were served was through me sending it over to them saying that this was filed. So how does the board want to proceed on that? Yeah, the rules were adopted at the last board meeting. And I would ask, just for the benefit of the court reporter, if we could speak into the microphone so that we can have an accurate record. I did get it in a timely manner, and then it was sent over to the objectors, possibly a day later, I think, just because truthfully, I'm getting about 200 emails a day. So I think it was sent to them either the day of or maybe a day later. They obviously chose not to file any sort of response. Either way, the parties have argued their case here today, so it really doesn't impact much, if you will, except it would either be included in the record or their arguments would be included in the record based upon the oral arguments that were presented here today. So it's kind of just a procedural thing. If the board wants to accept the late filing, it can. If the board just determines, no, we're not going to accept the late filing, it can certainly do that too. And the parties obviously have argued their case. You know, the case would, regardless of a motion to dismiss, the case would still proceed on the merits. And we just had an argument on the merits of the case. So again, it's up to the board. I'm sorry. Oh, no, you're allowed to discuss. Absolutely. So, yeah, I mean, I guess what questions do you have or what sort of? Oh, yeah, absolutely. In open session, all deliberations have to occur in open session. So it would be appropriate though to have a motion and a second one way or the other, and then have a discussion after that. So a motion to either approve the late filing or a motion to, not late filing. So a motion to approve the filing in manner of filing by Mr. Fields or a motion to deny the filing by Mr. Fields. And then the second, and then we can have discussion on that.
I'll make a motion to accept.
Okay, so we have a motion by Chair Gonzalez to accept the filing. Well, we got to speak into the microphone so that the court reporter can hear everything. All deliberations have to be in open session. So the board has discretion to deviate from its own rules. So if the board wants to say, okay, we'll accept the filing, the manner of filing, then that's the board's decision. If the board doesn't want to accept that manner of filing and say, no, you filed it incorrectly, we're not going to allow this document to be a part of the record, that's fine too. That's the board's decision. Either way, the parties did argue the case on the merits, so you will still issue a separate decision, if you will, related to the merits that were presented. And, you know, all the documents that were presented by the parties are, I believe, already in the record for the most part. And, so, yeah, it's really up to the board if you want to accept the late filing or not.
I say.
Or not late filing, the manner of that. So, okay, so we've got a motion to accept the manner of filing by Chair Gonzalez, a second by member Loretta Wells. I will now call the roll for that. Is there any further discussion before I call the roll? Okay, I will call the roll.
I'm a little confused because,
Well, the election laws don't actually dictate the manner. Well, the election law does not actually dictate the manner of filing or service of documents as it relates to these types of motions. That's actually dictated by the rules. And the board, under its own rules, can deviate from those rules should the board choose to. But that is a completely discretionary decision of the board. And so as of right now, we've got a motion and a second. So is there anything else that you wanted to state, Member Gray Everett? Okay, all right, then I will go ahead and call the roll. Chair Gonzalez. Member Wells.
Yes.
Member Gray Everett. Okay, motion carries. Mr. Fields, your filing will be accepted into the record. Now we're going to move
Can I
over.
put something, can you also make on a notice of record that you're ignoring the fact that he did not have a notice of service as well as a proof of service? Can we also put that on the record? I'd like for that to go on the record.
That's in the record. It's already in the record. And this is just related to the manner of filing in general. And that deals with the manner of filing. So that will be duly noted in the record. You know what, you can do whatever. First of all, this,
It could be personal. I'm talking to the board. It could be personal. They work with him, they know him, they don't accept the rules that they adopt. But if someone else that they don't know that well, then they can easily say, oh, no, we're gonna follow the rules. The rules are adopted for a reason. The rules are adopted so the board has a guideline of what they can accept or not accept. And to alter it because of possible relationship, that's a disservice to anybody else that is or may not alter it.
your comments are noted for the record. All right, so next we will move on to the actual deliberations for the objections that were stated. The first objection is that there's a failure to specify the office on the statement of economic interest. The objectors have stated and cited multiple cases from the Chicago Board of Elections, have stated that this is a fatal flaw in their view. However, I do note that there has been a lot of litigation on this case or on this issue. And most recently, there was actually a case last cycle at the Chicago Cook County Officers Electoral Board. And I'll have to get that citation, but there was a case last cycle at the Cook County Officers Electoral Board where the Officers Electoral Board determined that a failure to state the office is actually not a fatal flaw. Also, so there's a couple cases, a couple things I want to read into the record. In the Jones versus Municipal Officers Electoral Board case, the appellate court held that the candidate's statement of economic interest was not in relation to his candidacy when it did not adequately specify the office sought. Jones versus Municipal Officers Electoral Board held that third ward was not a sufficiently complete name of the office sought, and that the legislature intended to make mandatory rather than directory the inclusion of the office sought. That case was decided in 1983. About 15 years later, the court in the Illinois Appellate Court in the Requena case, Requena versus Cook County Officers Electoral Board, that court also dealt with this same issue. In the Requena case, the court determined that the candidate should not be removed from the ballot for failure to specify, to sufficiently specify the office she was seeking on her statement of economic interest. Additionally, in Cardona, Cardona versus Board of Election Commissioners of the City of Chicago, that was a 2004 case. The appellate court held that the election code does not require that a candidate specify the office sought. And again, that is a 2004 case. There is also a case that I personally worked on, Guerrero versus Franklin Park Municipal Officers Electoral Board. And in that case, the candidates did not specify their office on their statement of economic interest, and the appellate court found that that was not a basis for removal. So the appellate court has more recently held that a failure to specify the office is actually not a basis for removal. Given the case law that has been presented, it would be my recommendation, and the board, of course, will deliberate over this, but it would be my recommendation based on that the objection be overruled on that basis. So the board now can deliberate on this matter. Does the board have any questions? To overrule the objection related to the failure to sufficiently state the office on the statement of economic interest. Does the board have any questions on the law? Okay, so at this time, the board should, I'm sorry? So the law generally states that a candidate is supposed to file a statement of economic interest in relation to their candidacy. However, the case law that has been interpreting that, there has been a bit of a split. Like I said, the Jones case back in 1983 said that in fact was a fatal flaw. And I know the candidates, cited a bunch of City of Chicago cases. Some of them do say that, some of them say something a little bit different, but the overall, or I'm sorry, they only cited, I'm looking at a different one. They only cited Fortis v. Washington and White v. Thomas. Those are both 1987 cases. Since 1987 and 1998, as well as in 2004, the Illinois appellate courts have determined that the failure to state the office sufficiently on the statement of economic interest is actually not a fatal flaw, and the candidate should not be removed from the ballot for that reason. So that's the case law that governs this issue. So based on the case law, it would be my recommendation as the electoral board attorney that the objections related to the failure to identify the office sought be overruled. Right, but that's not the objection that we're dealing with right now. That would be the next one. Correct. And for the record, if the board wants to see, I do have the original nomination papers here. The office sought, just for demonstrative, is blank. So that's the question. Is that line required by law? And if it is required by law, is a failure to include that a fatal flaw? The courts have come out in the Jones and the Requena case and the Guerrero case. Well, if I may, the Jones, I'm sorry, the courts have come out in both in Jones, I'm sorry, in Requena and in Cardona, as well as in the Guerrero cases. The courts have stated that the remedy for mistakes on your statement of economic interest is actually not ballot removal. It is penalties of perjury. So the courts have stated that because there is this other penalty that's provided, the courts can't read into the law that the penalty of ballot removal would be the proper penalty. So that's where the courts stand on this. So at this time, I would need a motion to either overrule or sustain the objectors, the objection as it relates to the failure to identify the office sought. Okay, I have a motion to overrule as it relates to the SCI issue, as it relates to the office sought. Do I have a second on that? Okay, we have a second by member Loretta Wells. At this time, I will take a roll call on that motion, and this motion is specific to the failure to identify the office sought on the statement of economic interest. Chair Gonzalez.
Yeah.
Member Wells. Member Gray Everett.
I have to say no, because I'm out there. I filed petition. I will stop. This has nothing to do with I'm not fixing my own self. And that's not my, I'm not fixing it. I'm gonna fix somebody on the ballot, just because it in the office, and the state law says, then I'm gonna fix. If it has nothing to do with me, no, I'm not gonna do it for anybody else. Why not? Thank you. We were saying to follow, to make it easy. We're setting rules to be able to follow, to make clear policy. And so I just want to make sure that's what we're doing.
Okay.
Because I, individual too.
Okay, position noted.
And what you're saying, rather than being able to run.
Right, exactly, and that's exactly what the Illinois appellate courts have stated, is that the penalty for mistake is not ballot removal. The penalty for mistake is the penalty of perjury.
What we're saying.
Okay, thank you very much, Member Gray Everett and members of the board. Okay, so the next one we have on the list of objections for this specific candidate is that the failure to submit a stamped receipt of the statement of economic interest. I do have a copy, or I do have the original nomination. Have a proper stamp on statement of economic interest.
So the other one would identify off the phone, and then the other four, the other statement, it was one that they had.
Okay,
I'm gonna try this, guys. See. okay, so for the record, Mr. Fields did in fact file two statements of economic interest. It looks like one appears to be filed with the Cook County Clerk's Office, and that is this one that has the stamp on there. And then there was a second one that was filed. This one bears no Cook County stamp, but there was a second one that was filed with the Township Clerk's Office. But I do note for the record that this is actually the old form. And I can tell that just by the fact that it has $5,000 all over it, and the new form is, I believe it has 10,000. It's different questions, basically, it's different questions that were asked. However, the filing, the law requires that Mr. Fields and any other candidate for this office file a statement of economic interest receipt, file a statement of candidacy, and file the nomination petitions. Loyalty oath is allowed, not required, does say it's required, but case laws come out and said that, no, you actually can't require that. So those are generally the 3 documents that need to be included in every set of nomination petition, or maybe not per se in the actual set that's presented, but they need to be filed within the filing period. So as it stands, Mr. Fields has in fact filed those documents. There is case law related to people filing additional documents that are not actually required by law. So that case law essentially identifies those additional documents as surplusage, as essentially what that is additional documents that really have 0 legal effect on the petitions. So it would be my opinion that this additional statement of economic interest that is not even the current statement of economic interest that's in use is mere surplusage and has no legal effect on the petition. And as such, I would recommend overruling that objection.
Motion to overrule.
So my understanding is submitted full statement of economic interest. That wasn't stated.
No, they're saying, and the documents bear this out, that he essentially filed 2 statements of economic interest. One with the county, which is where he filed the receipt with your office. And the second one was this additional document, which is not correct. It didn't have to file that with you at all. Didn't have to file this one, period, because it's actually not even the correct form. Yes, exactly. If this was the only one, then we would be having a very different conversation. But the fact that there is a valid statement of economic interest in the packet that was filed stamped by the Cook County Clerk's Office on November 12th, 2024, and was filed within the filing period, as far as we know, with the clerk's office, the local election authority, then the additional statement of economic interest is mere surplusage and just essentially extra documents. So it would have the same legal effect as filing 5 extra blank pieces of paper, really, or filing a candidate profile with your nomination petitions. There is no legal effect to it. So we do have a motion to overrule the objection as it relates to the filing of the additional statement of economic interest that was not stamped by the county clerk. Do we have a second, or do we have an opposite motion? Okay, so we have a motion and a second on that. Okay, we'll do the roll call now. Or Member Graver, do you have anything that you'd like to offer? Okay. Chair Gonzalez?
Yes.
Member Wells?
Yes.
Member Graver? Okay, that one is overruled. Now, the next objection that we have is the failure to identify the office sought. I'm sorry, I would appreciate, right now, the board is in deliberations, so please respect the process. The next one is that the candidate is running as an independent and didn't state his party on his nomination petitions. They state in the objection that the objector's petition states, and I quote, section 7-43F clearly and unequivocally prohibits a person who voted the ballot of an established political party at a general primary election from filing a statement of candidacy as an independent candidate for an office to be filed at the general election immediately following the primary at which the person voted on the primary ballot. So what this is typically, referred to as, it's sort of an anti-party switching thing. So what it generally means is that you can't vote, say, Democratic in a primary, and then at the same general election following that primary, within the same election cycle, that you can't then either circulate for an independent candidate. So, or you can't circulate for a party, and you can't circulate for an independent candidate within the same election cycle. You can't vote for a party and then be an independent candidate within the same election cycle. Now, the question then becomes, what is an election cycle? An election cycle is the primary in general for that same election to ultimately elect those officers. So right now, we are looking at the municipal 2025 election cycle. We just got out of the presidential 2024 election cycle. So the primary in March that we just had, in March 2024, that was part of the November 2024 election cycle. The February 2025 election coming up is part of the April 1st election cycle. So you look at it in pieces. And it used to be many, many years ago that it wasn't looked at in such a piecemeal manner, that if you voted, say, in the March primary as a Democratic candidate, then you couldn't then circulate for the next year's April election as an independent. So the party switching, actually, the prohibition used to go on for 2 years. They changed it and said, no, it's only within each specific election cycle. So what you need to look at is whether any evidence has been presented, and whether there's even an argument, even if evidence was presented, that the candidates voting for an established political party at a general primary election, whether that impacts his statement of candidacy that says he's an independent. Now, as I stated, when we talked about what an election cycle is, the primary for this election is the February primary, not the March primary. So it doesn't matter under the law whether Mr. Fields voted in March for a Democrat, a Republican, a Green Party, a Libertarian Party, or an independent. It has absolutely no bearing on what is happening with this election cycle, which deals with the February and April ballots coming up. Try to explain it as clear in manner as I could. It's kind of a complicated thing. As it relates to this specific type of division, yes, because there is no, the way that it often gets violated actually is that people circulate in, for the February election, they circulate for the primary as a political party. And so they circulate. Please stop. Anyways, so they circulate at the general, or I'm sorry, they circulate for the primary election for a political party. Say they circulate as a Democrat or a Republican. And then they want to then run as a candidate or circulate for another person as an independent. So they can't do that. You can't party switch within the same election cycle. So I can't go out and circulate for a Democratic candidate for the February election and then myself decide that I'm going to be an independent candidate for the April, or circulate for my colleague who's running in April. So does that explain it? Okay. So as it relates to this specific objection, given the law, it would be my recommendation that the board overrule this objection, because there's been no evidence that the candidate voted in the primary. The primary is not occurred. That's February 25th, 2025. So as presented, the objection, in my opinion, is not well founded in law and should be overruled. Okay, we got a motion to overrule by member Chris Gonzalez, or by Chair Chris Gonzalez. Do we have a second?
Second.
Okay, I will call the roll. Chair Gonzalez, member Wells,
Yes.
member Gray Everett. Motion carries. That objection is overruled. Next, we move on the failure to bind the statement of candidacy to the nomination petitions. So when Mr. Fields was arguing, he was arguing more about the binding of the petitions as a whole. But what the objector's argument is not that the petitions in themselves weren't bound, but is that the statement of candidacy itself was not bound within the petitions. Now, as a practitioner, I can tell you that we always put the statement of candidacy with the petitions because that's what we believe generally needs to be done, and usually we feel that that's the best way to make sure everything is all nice and tight and neat and everything's going where it needs to go. The law on this is a little tricky though. So the law does in fact require that the nomination papers be neatly fastened in book form by placing the sheets in a pile and fastening them together at one edge in a secure and suitable manner. The election code also states that nomination papers must include a statement of candidacy. That's under section 10-5. The election code does not specifically state, however, that the statement of candidacy needs to be bound within the nomination petitions. So there has actually been a lot of litigation on this issue. The Nader case, this is Nader, N-A-D-E-R versus Illinois State Board of Elections, found that section 10-4 requires a petition when presented or failed shall not be withdrawn, altered, or added to. And that part of it has been found to be a limitation in some courts, or in some cases, to preventing the filing of the statement of candidacy as a separate document. However, because law is never 100% clear, that's why you guys always have to fight us. In 1984, the Chicago Board of Elections voided a candidacy when it determined that the candidate filed his sheets at 9 a.m. in order to preserve his ballot position in the lottery, and then filed a statement of candidacy and loyalty later at 10:34 a.m. Then for Valentine's case, Ballentine versus Bardwell, Bardwll. That case is cited as 132, Illinois 3rd, 1033. In that case, the candidates of the new political party were found to have substantially complied with the election code by filing their statement of candidacy 4 days after filing the signature sheets, but before the expiration of the filing period. It should also be noted that Valentine is a case that falls under Article 10, and why that's important is that right now we're dealing with Article 10 petitions. Just for the board's own edification, Article 7 deals with established political parties, and Article 10 deals with independent parties and new political parties. However, the first district appellate court allowed a candidate to remain on the ballot when the candidate failed to file their statement of candidacy with their nomination papers and instead filed them 3 days later. And that's Courtney, Courtney versus Cook County Officers Electoral Board, also citing Barnes, Barnes versus Benes, Benes. It's a Chicago Board of Elections case, 95 EB ALD 214, and Washington v. Means. That is case number 11 EB ALD 124. Those are also Chicago Board of Elections cases, all following the 10. This question, despite all this litigation going on about this and all these cases about this, this question came up again in 2019 in McCaskill versus Municipal Officers Electoral Board for the City of Harvey. In that case, the court opined that fortunately we can harmonize and give effect to each statute, i.e. the filing of multiple sets of petitions and the adding to prohibition. There are many ways a candidate might seek to add to the petitions in violation of section 10-4 besides filing an entirely new set of nomination papers. For example, the candidate might have omitted a required document from his filed nomination papers like a statement of candidacy and might try to add it later. Or the candidate might want to add more petition sheets to his filed nomination papers, fearing a lack of valid signatures. Section 10-4's language would still govern those situations, among others. We have not read that language, i.e. adding to, out of existence. So there appears to be a split amongst the courts, but the most recent word that we have is from the 2019 McCaskill versus Municipal Officers Electoral. And, reading this, our review on the case law is, truthfully, I think that this is a call for the electoral board to make to determine whether they feel that the failure to include the statement of economic interest in a bound manner with the nomination petitions. Whether the electoral board determines that that is some sort of, it impacts the integrity of the election process or the petitioning process, or whether it, it impugns some sort of fraudulent conduct or otherwise just impacts the integrity of the elections. So with this one, truthfully, I'm torn and I leave it to the board to make a decision as to what the board wants to say, because the board can really go either way on this.
In this matter, the question really is, whether this final say a set time, or say that it was generally accepted.
Correct.
Yes.
Correct. I mean, there hasn't been an allegation raised that it was filed separately, like a couple days later or anything like that. The allegation, as I read it, is that the statement of statement of candidacy rather, was not bound with the nomination petitions. So that's where the law always gets tricky. It is under some courts, and some cases, it appears to be required, and some, they dispute whether it's required. These cases range from, cases as recent as the Casco versus Municipal Officers Electoral Board. That's a 2019 case. That is a first district appellate court case. And that case appears to say to me that it is required to be bound with it, because otherwise it would be adding to the petitions after the fact. Like I said earlier, there are other cases which do predate that 2019 case, but those are the 2000 cases, or the 2000 case, that's the Courtney versus Cook County Officers Electoral Board case, where the appellate court said, they can go ahead and file, but 3 days later, it was filed within the filing period. No harm, no foul. So really, the courts are split on this, but the most recent word that we do have on that is from 2019, where the court in Casco basically said a failure to put the statement of economic interest and just put all the documents together, basically. Put everything together and bind it all together and file it all together, with the exception of the statement of economic interest, right? Because the statement of economic interest clearly under the statute can't be filed separately. There is statutory language as to that effect. But with the statement of candidacy, the ultimate question is whether it needs to be included with the nomination petitions. The Courtney case is definitely on point. However, like I stated, when I say it's on point, it's very similar fact scenario with the exception of in the Courtney case, the statement of candidacy was filed 3 days later. However, the McCaskill case did give a clear directive as well to state that under section 10-4, you can't add to your petitions. And is this considered adding to petitions? So that's really right. So that's really, what the board needs to sort of wrestle with. So the Illinois Election Code does not specifically specify that the petition, that the statement of candidacy needs to be bound with the petition, but that's been the overarching interpretation. Section 10-4 provides that the petition sheets be neatly fastened in book form. And then section 10-5 provides that the nomination papers must include a statement of candidacy. So the interpretation for the last 20-something years, or probably longer than that, at least that's about how long I've been practicing in this area, the interpretation has always been you put the statement of candidacy with the nomination papers. However, like I stated, the Courtney court, as well as the Chicago Board of Elections in a few instances, and the Valentine court have found that filing those separately can be okay. Now, us lawyers often use this one guide called the Illinois Continuing Legal Education Guidebook, and it's got this whole chapter on election law. I was reviewing that chapter last night, and in part of it, it does state that, well, in some jurisdictions, this is found to be okay. It's a very dangerous thing, and we highly recommend that candidates bind their statement of candidacy with their petitions. So, again, I think this is, the courts kind of are split on it, but the most recent word we have on it is from the 2019 McCaskill case. Well, in the Castle case, it said basically that you can't add to the petitions later. It sort of solidified that principle and, talked about that principle. I don't believe it actually specifically addressed the statement of economic interest, but it was talking about just overall filings, documents. So again, I think that there's kind of a split in the courts as to what the law is, but according to the Castle case, which again is the most recent case, nothing can be added to it. They do state a specific example where they say a candidate might have omitted a required document from his filed nomination papers like a statement of candidacy and might try to add it later. So the Castle court was specifically talking about a situation like this.
In that same 2019 case, says without any allegation of fraud or proof of the integrity of the process had been affected, they recommend against, overrule the objection.
Well, that was,
I'm going to say that's kind of right. Thank you.
so that, I mean, the board can certainly make a determination as to whether, they feel that the board, whether they feel that the failure to include that impacts the integrity of the process, or whether the board feels that strict compliance with section 10-5 and 10-4 is required.
Well, not, usually election code, you have to find. I'm sorry. Usually, if I've read it correct, I mean, my interpretation is that you are supposed to bind all the documents together.
Okay,
So,
okay, so do you make a motion to sustain the objection as it relates to the failure to bind the statement of candidacy with the petitions?
yes,
Okay, so we have a motion to sustain the objection as it relates to the failure to bind the statement of candidacy with petitions. Do we have a second on that?
Yeah.
Okay, so we have a motion made by member Loretta Wells and a second made by member Darlene Gray Everett to sustain the objection as it relates to the failure to bind the statement of candidacy with the nomination petitions. I will now take a roll call. Chair Chris Gonzalez.
No.
Member Loretta Wells.
yes.
Member Darlene Gray Everett. Motion carries. The objection is sustained as to the failure to bind the statement of candidacy with the nomination petitions. And finally, we do have one last objection in this matter. This relates to a failure to list party affiliation on the statement of candidacy. In that objection, the objectors list section 710 of the election code. And I would just note that 710 is not applicable in these proceedings. It's actually, so that's an incorrect citation. And in addition to that, as an independent candidate, Mr. Fields is not technically required to list any sort of party affiliation. And there is plenty of case law saying that if somebody files, say, a nonpartisan nominating petition for an independent race, that's okay. So it would be my recommendation to overrule that objection.
Yeah.
I make a motion to overrule.
Okay, the motion to overrule made by member Wells. So we have a second? Okay, Chair Gonzalez,
Yes.
member Wells,
Yes.
member Graham.
Yes.
Okay, there being no other objections related to this, Mr. Fields, there will be a written decision and objectors. There will be a written decision drafted and we will come back here. Do you guys want to try and settle on a date now? That's, let's you have to come back and just actually substantive decision. Let's look at our calendars real quick. Does December 30th or December 30th, preferably December 30th work? December 30th is a Monday.
Can we do something? Is that for my court too?
We would be hoping to schedule them all on the same day. Sooner, not really, because we're gonna need time to write the written decisions.
Like right after Christmas.
That is right after Christmas. I'm not gonna be in town the 26th or 27th.
30 is fine.
30th, remember Gray Everett?
Do I need to be here?
Okay. Okay. Okay, well, this will, so this will be just to issue the written decisions. So if you're not able to be here, member Gray Everett, and member Wells and member Gonzalez are able to be here, then that's fine, as long as we have a quorum. And this will be solely for the purpose of issuing the written decisions. So again, yeah, I would say 10 a.m. And in relation to the trustee cases that'll be coming up later, if those cases are fully adjudicated, this will, this date will be reserved mostly for written decisions. If there's anything substantive that needs to happen, at least on the supervisor cases, we will try and work with your schedule. Another great. Okay, so this matter, I just need a quick vote from the board to continue this matter to December 30th at 10 a.m. for issuance of the written decision. And just for the record, the written decision is that Mr. Makefield's name will not appear on the ballot. He has removed from the ballot as it relates to the one objection for the failure to bind the statement of candidacy with the nomination petitions, and all other objections were overruled, and the written decision will reflect that. A substitution, I'm sorry, I don't know what you mean.
The 30th basically, we asked a question, right?
Sure.
So the 30th, we waited on, the 30th basically going to be,
The decision has already been made. So this is just issuance of a written decision that reflects the matters that were discussed here today.
So the decision doesn't make, because, so the decision has been made that I'm not going to appear on the ballot. So as an independent candidate, right?
Yes, because the objection was sustained as it relates to the failure to bind the statement of candidacy with the nomination petitions. And that was sustained on a 2-to-1 vote.
Although the documents were filed at the same time together, in good faith, the electoral board agreed that I'm not eligible to be on the ballot, although it was filed together in good faith. Even though I worked this hard for signatures and for Thornton Township, our board can't come to a decision to determine that simple mistake as far as faithful and simple advising the details to me. I don't think it's fair.
Well, you do have appeal rights, sir. And once you get the written decision, and the written decision will reflect that you have 5 days to file an appeal with the circuit court. And so at that time, once you receive the written decision, you are certainly more than welcome to file your appeal. We would put together the record, and then you would make your case before the circuit court. As you heard during deliberations, the state of the law was read to the board, and this the determination that the board made. So the written decision will be issued on December 30th at 10 a.m. So if you would like to appear in person for that, you certainly can, and we will give you a copy of the written decision once it's signed by the board. If you are unable to appear, you just can let us know that you're waiving personal service as it relates to the statutory service for the decision, and we will email it to you.
Okay.
Mr. Price, Mr.
Smith,
Yes, ma'am.
do you waive statutory service of the decision?
Yeah, the long as this email will find.
Okay, so they will accept email service of the decision. Okay, thank you. Great, we have to move on to the next case. The next case is Demarcus Quigley versus Stafford Owens. Mr. Owens, is Mr. Owens here? Okay, so Mr. Owens is not here, and as the board knows, Mr. Owens was invalid from the other two. So it would be my suggestion to the board to, Mr. Quigley, are you asking for Mr. Owens to be defaulted? My suggestion to default Mr. Owens and to order that the same not clear and valid. So I would ask for a motion to that effect. You think we have a second? Okay, member Loretta Wells? Chair Gonzalez?
Yes.
Chair, member Bayard? Okay, Mr. Owens' name, as in the other case, it will not appear. And he is defaulted. Yep. All right, next case, William Long, versus Nate Fields.
They didn't get him from the other angle. They were getting from the back door like you like. I told her. Glasses on.
Sorry, just bear with me one second. Oh. Okay, thank you both. The objections against Mr. Fields filed by William Long and Julie Harris. Both parties have stated their names and appearances for the record. The first order of business is related to the failure to file the correct statement of economic interest. So at this time, well, I'm sorry, I've been totally jumping the gun here. At this time, the parties are allowed to have their oral arguments. Mr. Fields, just like in the last case, Mr. Fields did file a motion. However, that motion was filed not in the correct manner. Finally, it didn't have the notice of filing, didn't have the certificate of service, and it was filed with the clerk's office. So at this time, I'll ask you to scratch up if you have any objection to the board accepting that motion into the record.
Yes, because I didn't see that.
Okay. Okay, so, all right, so there is an objection to that, so the board will make a decision on that when they start deliberating, but in the meantime, Mr. Fields, you're obviously, even if that motion is not accepted into the record, you're allowed to make your arguments based upon the objections that were filed against you specific to this case.
Okay, I did file a response with the Township clerk's office. Within a lot of time, I was told verbally that this document will be emailed to the attorney. That's it, that's all. I filed the response, timely manner, bill based. It should be held. I do have a response, if you like to see it, I do have a copy of it.
Thank you.
Yeah, it was my,
Okay, did you want to argue your case?
As far as the, so.
Well, actually, I'm sorry, order of procedure. Actually, since there is an objection to the motion, and Ms. Cracker, just for the record, Ms. Cracker, I did vote, and I did send it to you, albeit a little bit late, it was on December 12th at 12:03 p.m. Oh, so probably got, probably get the things somewhere in your email. So that, considering that it was sent out, and yes, Mr. Fields, go ahead and state a response to the objection.
Okay, so the objector,
I'm great. Come on, man.
said.
Hi, how are you?
I don't think nobody else coming in, right?
Yeah.
It's just the news.
Just move.
You got, come on, y'all, come on in, we can fit you in, come on. You sure? 100% sure.
I could just leave my camera in there. I don't have to be in it.
Go ahead, go ahead.
Okay, thank you. Okay, guys,
We gonna make room, we make room for everybody.
thank you.
That's what we do. Take care of everybody.
I'll follow you on Instagram.
What's
No,
your name?
I'm Burgundy Blue.
Burgundy Blue?
Mhm. Nice to meet you.
Oh, no, that would imply
I'm gonna
authority
try
of
not
some
to-
sort. Responsibility and accountability. We want none of that. No.
Oh my God,
Honey?
I'm gonna do my best. Critical, we miss you.
Close that door, right?
Critical smoke, come back.
Great over.
No,
You? Second. No, don't apologize.
I can sleep.
Well,
You want to go right there? I'll go right here. Is that okay?
Yeah, you break it, you buy it, right?
thank you, that's
All of them.
Okay, guys. Hope y'all do the best I can.
I only want to talk to the news.
Okay, okay, okay.
Okay, all right, so then, okay, sorry.
All right, no, thank you. Yeah.
sorry about that.
You could have just directed me. I'm the only blogger in here.
Oh, really?
I think
I thought
so.
everybody was bloggers. She said everybody else. She said all others.
Oh, she said, oh,
Is this good?
go back.
Like,
in?
Right
Okay.
here?
He said I could go back in. Okay, he let me back in.
They'll let you back in?
Yeah.
All right, okay, no problem, good. It should, you shouldn't have been picked up.
Okay, they let me back in, guys. Let's see.
Okay.
Yeah. Oh, yeah. They,
Yeah. It's like, you got that? It's painful. It's really painful. What? Yeah, for sure, yeah.
I'm just
What is that about? Is that a control thing or is that a?
No,
just a control?
Smart aleck trying to delegitimize
Well, yeah,
hyper local.
because you know what's gonna happen though, right? You know what's gonna happen. All we're gonna do is go out there and play the whole thing for you, let you record it and keep it moving. Right?
Thank you.
Right?
It's all power, control,
Yeah.
intimidation, yeah.
Okay.
At least nothing new, right?
The news people are really cool. They said if I get kicked out, they'll still just give us the video.
You know what to expect.
Predictability.
Now, I haven't covered anything out here. I've just been, whatever I read.
I
So
try to
can-
just
I can
follow the
quickly
rules. I don't know what's
to-
going on, y'all.
To start, with some questions and whatnot, because I don't, where should we focus, I guess is what I'm asking.
Yeah, I mean, I know I'm gonna ask you about like her status and that.
They let us say,
Yeah, that's.
say if not exploited, they'll give us the video and let us see.
Okay.
Right, because she was on.
Well, I'll still ask her.
But you still gotta.
So they may kick me out still, guys. I don't know. So y'all, I'm not plugged. I don't know anybody. I'm just covering it. I'm not on any side. I'm not on anybody's side, just covering.
So what I had said to her, I said, she said, what have you talked about? I said, everything. I said, this process, your job, all of it. Well, I'm sorry, I don't have a filter.
She might go for like.
I don't have a filter.
I mean, it's not a big surprise, right?
Well, it's good that you take it. We'll take it. Yeah. no, I'll take a little bit.
Scoot back from that.
Yeah, I'll take a little bit, but I'm just saying,
Yeah,
Okay.
don't, this ain't my party.
Oh, thank you. That's
Put him a visitor.
Yeah.
that better?
Yeah.
Okay,
Thank you.
you're welcome.
You know what I've been thinking
We're
about?
gonna see.
Dunkin' Donuts. Have you?
Let's see if they I don't want to postpone. I don't know if they're like,
No.
like I said, when they say bloggers, I'd be like, well, I just report the report. I'm not a journalist. Everybody's reporting on it.
Yeah.
So you can't stop opinions. Everybody's gonna have an opinion.
All right, and you're taking your time to be out here, wording it, share it with people.
Yeah.
So,
Just eat it just like it is.
I'll look into it.
Yeah, I thought of it,
So we're missing the hearing. Would you guys rather see this or would you rather me go outside for the hearing? Let me know.
that'll be my little treat. For me. Should I see what they do in the records anymore?
For the, oh, okay. Where are you? I always see your mask. Where are you from?
I'm just gonna go see what they do.
Oh, I love y'all videos. Yeah, they're nice and clear. Yeah, really good videos. I saw all of you guys before. I just could. I follow everybody in here.
that's awesome. Thank
Yeah,
you.
thank you.
I have an objection.
Oh, really? I still gotta put in my FOIAs for all sorts of stuff for this.
If you want the objections, I'll send them to you.
No, that's fine. I gotta send some stuff for everything. I want that package too. I got questions.
Yeah. I got questions. I'm worried
Always
that we're
questions.
just gonna keep us in here for a long time and we're gonna miss
Yeah,
what's
the
out there.
decisions.
That's my worry. I don't wanna just be standing in here like a fool.
Yeah, because they took all the media out, right?
Yeah.
By design.
Can you let Evelyn in?
Let's see. So currently they took all the media out the room, so we don't know what's going on out there.
Must be something wrong with me because I don't care.
No, it's nothing wrong with you.
It's because you're behind the camera.
But I'm the only one here, so I should be listening too.
Okay. My people are saying, go back out there. Go back out there. Definitely go back out there.
All right. She's only talking to the actual news. She's not talking to, she doesn't want it.
Okay.
We are actual news.
Well.
Yeah, what does that mean?
I don't know.
I'm from the Lansing Journal.
Yeah.
She does consistently reporting online just because we're
The
online.
same thing. That's not my call. So, for her to interview with them,
TV.
What's she gonna talk about?
TV. I'm not sure. I'm sure they'll air it.
Well, why are we playing these games? I don't understand. We're coming in. we're
I don't
going
know.
out.
Did you ask the electoral board while they're playing games?
Well, let's talk about it.
No, exactly, that's the thing, we just wanna talk
Let's
about.
talk about
Did
it.
you ask them why they were
Let's
changing
talk
rules
about
they
it.
adopted?
Let's talk about
Print
it.
news, not.
The Tribune can say here?
Yeah,
That's news.
That's definitely
They're
new.
more than 100 years old, so.
No, I don't know. I mean, it's definitely like the TV thing, it's fine.
I don't know why you can't.
She likes being on TV.
Right.
It's just like the thing.
All right, we're headed out. So the Tribune, I don't know why the Tribune can't be in there. That's weird.
Yeah.
Are you with?
Is your opportunity, Mr. Fields, to go ahead and do your oral argument right now?
Okay, so, the objector, Sheila Ashley,
Okay, let's go back, guys.
alleged that I failed to file a statement of
I don't know,
economic.
you just gotta let me know.
Keep the Tribune out.
Did not include the required receipt, verifying this filing. But these claims are unfounded. On November 12th, I filed my statement of economic interest with the county clerk as required by section 10-5 of the Illinois Election Code. I submitted the stamp receipt of this filing along with my nomination papers to the Thornton Township Clerk's office. I've included that exhibit attached. To ensure transparency, I also filed an additional statement of interest. The Thornton Township Clerk, while not legally required, this action underscores my commitment to meeting all procedural and ethical requirements. Now, number two, the objection regarding the withdrawal of previously filed nomination papers. The objector claims that I failed to withdraw previously filed nomination papers. This objection is without merit. On October 21st, 2024, I filed my initial set of nomination papers as an independent candidate. On November 12th, 2024, I filed an additional set of nomination papers for election as an independent candidate for Burgundy Township Supervisor. These filings were not duplicative or conflicting or remain to ensure proper implementation of my candidacy. Now I'd like to make a note of the notification from the election authority. Under section 10-7 of the Illinois Election Code, if multiple sets of nomination papers are filed, the election authority is required to notify the candidate within 2 business days. And the notification must inform the candidate that they have 2 business days to withdraw all but one set of petitions. I did not receive such notification from the election authority regarding multiple filings and that the previous set of petitions must be withdrawn. In fact, the election authority informed me that the first filed set of petitions cannot be withdrawn. I did leave that exhibit be attached. Now, without the required notice, there is no obligation under Illinois law for myself or a candidate to withdraw a previously filed set of petitions. Now, as no notice of multiple filings were issued by the election authority, no action was necessary on my part to withdraw any set of nomination paper. This objection assumes a requirement or withdrawal that does not exist absent on the written dated notice from the election authority. I will comply with all requirements of the Illinois Election Code by regards to filings of my statement of economic interest and the associated receipt. The election authority did not require me to withdraw my filings, eliminating any obligation for me to withdraw a set of nomination papers. My filings are valid. And my candidacy remains in full compliance with Illinois law. Conclusion. The objectors claim that I do not identify. The objectors claim do not identify with any substantial or material defects in my nomination papers that would disqualify my candidacy. I respectfully request that these objections be straightened and dismissed in their entirety.
Okay, in response, Mr. Avery?
Very briefly, the statement of economic interest receipt does not state the office over which the receipt was filed, which is violating the election law. There was an original allegation that one was not filed at all. That's usually that one was filed, which is not proper. But the biggest problem that we have is the 2 sets of nominations that are consistent. And the problem with Mr. Field's argument on that issue is that he is confusing withdrawal of the papers with withdrawal of the candidates. Right now, as we are sitting here on December 17th, Mr. Fields has 2 sets of nomination papers for the same office, albeit for different elections. That is not permitted by law, and he started granting because that list is on the board, and there's no having to possibly use on looking stuff to paper. So his reliance on the October 24th letter says you're not withdrawing these papers. It's not proper. He should have. He did not. It's the seat that he did not. He should have withdrawn that original candidacy because that candidacy still exists as of that. So that reason, and the reason stated above, the motion to dismiss should be denied. Means the board is considering the whole matter. For it, the board should sustain all kinds of objections to somebody that's not.
Thank you. In response, or number 500?
The letter from the election authority does state that Section 710 of the and 10-4 of the Illinois Election Code require that once a petition is filed with the election authority, it shall not be withdrawn. Also, since I filed my petition on October 21st, 2024, I filed up to 22 days before the start of the correct filing period. As such, Since I filed prior to the start of the independent filing period, my nomination papers and my eligibility as a candidate are not in apparent conformity with the Illinois Election Code. Meaning that my papers are as good as gone if I filed within the wrong filing period. But the election authority did tell me that, well, on this letter, that they shall not be withdrawn and that she cannot give them back to me. So from my understanding is that from the election authority telling me they shall not be withdrawn, they shall not be withdrawn. And that concludes.
Thank you. I think the first order of business is to discuss the motion. The technical, or sorry, the manner of typing the motion. Does the board want to accept, this is the same thing with the other cases, does the board want to accept the motion into the record? Okay, so we have a motion by member Wells to accept the motion into the record. Do we have a second? Second by member Gonzalez. I'm sorry, Chair Gonzalez. Chair Gonzalez, what's your vote?
Yes.
Member Wells? Yes. Member Graham? Okay, so the motion will be accepted into the record. So now we're going to move over to the rulings as it relates to the motion and the ultimate objection. So as it relates to the statement of economic interest issue, I do know for the record that the candidate has in fact, as stated in the other cases, has filed a statement of economic interest receipt that was filed, stamped by the county and was filed and then filed. In addition to that, candidate also filed an additional statement of economic interest that was basically from the old statements of economic interest. And as stated in the prior cases, it's still my position that that is just mere surplus and that those additional documents have no legal effect. The objectors have also stated that the candidate has failed to sufficiently state the office sought. As in the initial case that was before this board, case number 25 TOE B Soup 02, my recommendation also remains that that objection be overruled and for the reasons that the statement of economic interest does not necessarily have to state the office. It should, but again, there's some of the situations where the case law, particularly the Guerrero case, and some of the other cases that were like, some of those cases do state that the failure on the statement of economic interest and mistakes on the statement of economic interest now results in the candidate's removal from balance. But I do want to take a look at the objection real quick. I'm gonna make sure that this just bear with me 1 minute.
Tell them something. Sure. That's what she said. I said, you can see what she don't understand. Yeah, come first there for him. Why did you? No, but that's what she did. So, why? Why don't you? Why? So did you say like to a boy, but I didn't follow the rules there. We're here for it.
You should have told her though, like she said that she should have told her. You wouldn't have been on
So I was thinking we were looking at the objection, I actually don't think we have an objection as it relates to the statement of the office.
So, the rules obviously.
If I'm correct, if you could. Don't be worried.
We need that. Congratulations. Saying all congratulations. But I don't receive congratulations.
Okay, so that was something that was raised in the response.
Yeah, the original one's back from the in-house down, like, I'll say the economic interest and then some. Came back and said, I bought that fee. But then had the office go to the response and said, yeah, they have filed receipt, they have filed. Any office, they'll be escape. Third floor or something.
Okay, so, okay, so I just want to be clear for the record, because, just, something like the board should know is that once filed, an objection cannot be amended, so you're not per se amending their objection, you're just saying the same way the economic interest receipt is invalid, basically, because it didn't have. Okay. All right.
Limited the response to what he submitted as a permanent matter in motion. Contains no.
Okay, so as it relates to the statement of economic interest received and the findings, or the, as it relates to the statement of economic interest received, one does exist in the file. And as stated in the prior cases, the Guerrero case and some of the other cases that were cited in the other cases, that is not generally the tally. So that's Guerrero, Requena, RDQUEMA versus Cook County Officers Electoral Board, and Cardona versus Board of Election Commissioners of the Chicago. So it would be my recommendation to overrule the objections as it relates to the failure to file a statement of economic interest. And just to be clear, the objection was more so the failure to file a statement of economic interest, and the objectors in their response were saying, well, even what he showed us that he did file doesn't match with what the law. So the objection is really the failure to file a statement of economic interest. It's one more thing. And again, based on everything, this law isn't compliant. So my recommendation is to overrule that objection. Okay, do we have a second?
Second.
Okay, Chair Gonzalez, Member Wells, Member Everett. There's also a motion for failure to file the statement of economic interest with the appropriate authority. As we can see, the statement of economic interest does have a Cook County stamp on it, and it was in fact filed with the village, or with the township clerk as during the final hearing. So it would also be my recommendation to overrule that objection. You made the motion with a second. Motion made by Member Wells and then seconded by Chair Gonzalez. I'm gonna call the roll. Chair Gonzalez. Yes. Member Wells.
Yes.
Member Gray Upper. Motion carries. Now, the next objection that I have on my list here is an allegation that the statement of candidacy is false because of the mistakes with the statement of economic interest. The board has ruled that the statement of economic interest is fine the way that it was presented. So as a result of that, I think that the board, my recommendation to the board would be to overrule the objection as it relates to a false statement of candidacy.
Motion.
And do we have a second?
Second.
Okay, Chair Gonzalez,
Yes.
Member Wells,
Yes.
Member Gray Everett. Motion carries. Okay, so then the next one is the filing of multiple sets of nomination petitions. This one is a little tricky. Section 10-4 states that no person shall circulate or certify petitions for candidates of more than one political party for an independent or independent candidates in addition to one political party to be voted upon at the next primary election or general election for such candidates and parties with respect to the same political subdivision at the next consolidated election. The court in Stevens versus Educational Officers Electoral Board found that by filing the second set of nomination petitions, the candidate violated section 10-4. In that case, they had filed two sets of nomination petitions for the same office during the same filing period. The Illinois General Assembly, in response to that, enacted 10-6.1, which basically provides that when somebody files multiple sets of nomination petitions for the same office, the local election authorities generally to give them notice within 2 business days that the candidate did not, or filed multiple sets, and then they would have 3 business days to notify the local election official which set that they are withdrawing. If they fail to do anything, or arguably if the local election official doesn't do anything themselves, then the last set of petitions on file would be the only petitions considered valid. And McCaskill versus municipal office. In McCaskill, in McCaskill versus Municipal Officers Electoral Board for the City of Harvey, the Illinois Appellate Court overturned Stevens, holding that the enactment of section 6.1 so their candidate can cancel their first set of nomination. In that case, the candidate did not withdraw his first set of nomination, I'm sorry, in this case, the candidate did not withdraw their first set of nomination petitions. However, those nomination petitions were filed outside of the filing window and were rejected by a local election official on apparent conformity because the candidate had attempted to file independent nomination petitions, which are governed by Article 7 during the Article 7 filing period, which is for established parties. Well, the local election official may have been required to tell them to file multiple sets. The candidate's name was not certified to the April 1st ballot as a result of his first filing. Was then certified to the February 25th ballot as a result of his first filing. It's not going to be the February 25th election. In regards to the Sorority case, my understanding of Sorority is that the candidate had filed multiple sets of nomination petitions for the same office during the same filing period. The board in that case found the petitioner stating that candidacy failed to state his instance qualified voter. I'll get to the actual portion of the case that's for the case of this.
Hey, what y'all got going on? Working or you on about? Is there strawberries? You know the stuff they usually come in. Some of the same light skin guys that it's
Can I make a statement regarding?
I'm sorry?
Can I make a statement regarding Sorority?
In a moment. I guess, yeah, go ahead. That's fine. With Mr. Avery will be allowed a response.
Okay, so yeah, Sorority versus Bloom Township Electoral Board. That's pretty much misplaced. In Sorority, the issue arose when conflicting nomination papers created ambiguity for the electoral board. It's a conflict when it's filed within the same filing period. So here, there's no such conflict because on top of that, the election authority explicitly directed that the first set could not be withdrawn. I filed within a totally different filing period. And so my second filing made within the statutory period resolves any potential procedural issues.
Okay, in response, Mr. Avery?
Well, we're on the base of authority on these potential problem that Google filing places on the electoral board, which we have here, and we have that here because the candidate misinterpreted the first letter. You say they couldn't withdraw papers, petition, file. While that might be true, the candidacy could have been withdrawn. Well, so right now, Mr. Fields has two candidacies. That is not right in the law whatsoever.
Hello.
So. Again, this one for the board, I would say that this one is kind of, a tougher, because obviously Mr. Fields did file two sets of nomination petitions, that is not a dispute. One set of nomination petitions was filed during the filing period, for the primary election. So that was the October filing period, and another set of petitions was filed for the November election. And while the election code does not permit the clerk as the local election official to return the nomination petitions, that does not prevent a candidate from withdrawing their candidacy should they so choose to do so. However, at the same time, the apparent conformity letter, which is what that letter is commonly referred to, the apparent conformity letter that was sent to Mr. Fields did in fact say that your name will not be printed on the ballot.
I think you gave me the prescription on.
So there, may have been some confusion on one side or another. But either way, it is up to the board to determine whether that dual filing, if you will, whether there's any legal effect to the initial filing, or whether the apparent conformity letter that rejected that initial filing, whether that initial filing be legal nullity, meaning that it doesn't mean anything, and that the petitions were only kept on file simply because the local election official under the electric book is not allowed to do anything on their place. It specifically says shall not be withdrawn. So the question for the board is, does that dual filing affect the integrity of the process? And as stated previously, in the McCaskill case, which we seem to be citing, McCaskill seems to be coming up a lot today. The Illinois Appellate Court overturned state holding that the enactment of section 10-1 made it so a candidate can cancel their first set of nomination petitions. Now, obviously, Mr. Fields has not per se canceled his first set of nomination petitions. However, the board should note that there was in fact the apparent conformity letter that was sent to him that did essentially tell him that your candidacy is essentially legal nullity, your name is not going to be printed on the ballot. So the board needs to figure out for itself whether this act of filing with multiple nomination papers caused confusion or somehow affected the integrity of the process. Yes, ma'am. No, he filed both sets of petitions as independent. And that was the reason that was one of the reasons that those petitions, and that was actually the reason that those petitions were returned, is because if I don't think the wrong filing period. Because the independent filing period in that was when it was November 12th to November. Yeah, both times he filed as an independent, just the first time he filed during the established political party period, which again, was not really happening because there was no primary being held in Thornton Township. So anybody that filed during the filing period had their petitions rejected because there was no primary. So he filed for an election that was not actually happening. And he filed petitions under Article 10 during the Article 7 filing. Well, then this is why we always recommend getting an election attorney, it's not for self-preservation. Because this stuff is tricky. So it's, yeah, I leave it to the board, you know, giving you a law, I think this is kind of a judgment call on the board's side, you know, whether the board thinks that this impacts the integrity of the process, whether it causes confusion. And if the board feels that it does, and feels that the things that the Zarate case was trying to caution against, if they feel that those things are in play here, you know, again, the confusion of both the elector, the confusion of the both election officials and of the electoral board and the inconveniencing of everybody. If the board feels that that occurred, then the board should sustain the objection. Well, this was kind of a legal nullity because there was not going to be an election anyway. It didn't have any impact on anything. And the first set of nomination petitions have no legal effect. That could also be the board's finding, and the board could overrule the objection. So I think that those are the board's two options. Obviously, sustain or overrule, which would also be in part granting or denying the motion to dismiss.
Scarcely the right word. What's the process?
He could have sent in a withdrawal of candidacy. Yeah, that's what it's a notarized document.
That wasn't exist now. Sorry.
Yeah, let's, here, we'll make sure to
Yeah.
share the mic right now, because
You say something about confusing. How can
so the argument would be that the electors would be confused or just by, I guess, by thinking that that he's running for two separate offices. I mean, I think that in this case, with the fact that the February election was not actually occurring, that argument for confusion gets deflated some. That would be my opinion.
I'll make a motion.
Okay, so we've got a motion to overrule the objection. And do we have a second on that? Second. Okay, we've got a motion made by the chair, Gonzalez, to overrule the objection, and a second by member Wells. I'm gonna take a roll call. Chair Gonzalez,
Yes.
member Wells,
Yes.
and member Gray Everett. Motion carries 3-0. And just for sake of clarity, that's also basically a granting of the motion, striking dismisses or replace that in a motion overruled. And that will be reflected in the ballot or in the petition. I'm sorry, in the written decision. And the candidate's name will appear on the ballot for this case. Obviously, if your other case that takes you off, but for this case, the objections are up. And we will issue a written decision that will be on December 30th. Mr. Avery, do you waive statutory in-person service of that decision?
Yeah.
Okay, and Mr. Fields, do you also waive statutory in-person service of that decision?
Yes.
Okay, thank you. All right, there being nothing further with this case, I think at this time, we need to call, the next case on the docket. And that is Sheila Ashley versus Sydney Moore.
You're stepping up.
Good morning, Your Honor.
Okay, parties, please state, spell your name for the record. Objector, you're dealing with Brett case.
Jim Avery for Sheila and Gypsy.
And good morning, Your Honors. Right, so we're going to have down our attorney Frank Outlaw on behalf of the candidate Sidney Moore.
Okay, and, Mr. Avila, I don't think you were here for this earlier, but, in order to try to expedite these matters as quickly as possible, because we obviously have a very full docket today, we are instituting a 10-minute oral argument rule, so that all parties will have 10 minutes. You can obviously, as the movement, you can split your time up however you so choose. And then my associates by left will be tracking everyone's time. When it gets to the 2-minute mark, she will raise her fingers for 2 minutes. When it's the 1-minute mark, she'll raise her fingers for 1 minute. So please adhere to the time requirements. It's your motion.
Okay, Your Honors, I will take 5 minutes for my motion and then 5 minutes for my response or reply. So Your Honor, the first item is that we don't take the objector as standing. The objector lies standing because she's not a registered voter, or at least not a registered voter at the Congress listed. And I cite the case law in 10 ILCS 5/10-8. And I also cite the case law of Drug versus Illinois State Board of Elections 387, Illinois, 3rd District 144 in 2008. And the drug holding was also affirmed in Manuel David. Also, Your Honors, I also provided 5 pieces of case law on the same topic, which is the Township case, which is controlling the public court case, the Robert F. Kennedy case, and 2 other. There's the opinion by the hearing officer, and there's a hearing by the board by both of those. And then I provide 2 other cases. So I do provide 5 cases that I said that I would be utilizing today, and I just want to cite those here, and I did forward those emails. Your Honor, and so I believe the objector has failed to comply with standing requirement in 10-8. I also will cite copies of Cabin, Mayors versus Holmes, and Bunder and Miranda versus Hernandez. All the citations are in my motion. On the second issue, Your Honor, I won't belabor that point because I know I'm in a time crunch here. I also believe that the argument that my client filed in the Democratic primary and thus is not eligible to be a candidate as an independent is not legally and factually supportable objection. First of all, Your Honor, the dual circulation restriction was added to section 10-4 1975. And of course, that's 10-4 of the election code 10 ILCS 5/10-4 through HB 526, which gave a public act 79-1100 act September 26 of that same year of 1975. Public Act 79-1100 with legislative debate, and later PA Public Act 82-1057, and that's attached as our Exhibit A. Your Honor, in the sum of this issue, there was no Democratic primary. So many people, I've been listening to other cases here, filing Democratic primary, because it's normal to assume you have a primary for local races. In this particular case, there was one because the committee did not file the requisite did not file the requisite paperwork to have a primary. So there was no primary. There was no Democratic primary. There was no race. So there was not filing for 2 offices because there was no race. And I do cite various case laws, and I also do cite some in reply. I make analysis there. I filed Westbury versus Sanderson and Anderson versus Mills, and I discussed the sore loser section of the Kentucky election law, and I discussed the dual circulator provision, Ms. Castle versus municipal officers electoral board, and Heelan versus municipal officers electoral board, etc. We have, of course, our motion to strike and also our reply. What I could say also is this, that this violates due process violation. As my client, his due process was violated and that's equal protection violation. But I think the sum of it, my client should be found down the ballot because it's 2 different races. You have one Democratic primary, which never happened. And you had one race, which is Catholic, which is as an independent candidate. To the extent there was no race at all, there was no contest, there was no primary, there's no paperwork for a primary, that means there was no primary, there is no other candidacy, there is no other race, there is no dual candidacy here, and the objection should be stricken, and I ask you to grant my motion to strike this.
Okay, thank you. And before Mr. Ingrid gets started, and I'm sure that Mr. Ingrid will address this, I just want to advise the board that the board, under the election code and under the authority given under the election code, the board does not have the jurisdiction to rule on constitutional issues. So we will accept the arguments into the record, and this is how this is normally done. Parties will make arguments on constitutional issues. The electoral board accepts those arguments into the record, but we cannot make a ruling on constitutional issues because of lack of jurisdiction, but it does allow the candidate or the objector, whoever raises that constitutional issue, it preserves their rights on appeal to pursue the constitutional question. So the board does not have to weigh in on that issue, and that's why the confidential board memos do not address that, but just wanted to educate you on that to make sure you're aware. So with that, Mr. Avery, this is really a argument.
Well, the first one's very simple, with regard to the objector's standing. The basis for the intention in the motion to dismiss was the inclusion of one additional number, forgot it's called in this case, in the matter of the objector. Instead of being 14920, a number listed as 11420. The objector responds to the allegation has submitted the objector's voter registration back to that 14920 college. So that moves forward. This actually has a standing as a duly qualified and registered legal voter. Now, you could say, well, that's an error. Those types of errors of one digit in an address were excused for a candidate. I believe that was in Cunningham versus Shaw. The objector said the candidate is not a resident of the location where we are having this election. They said, oh, I put my wrong address on there. 6924 instead of 7924, that 10 blocks put the person's here out of history. So if a slight error on a candidate's address was overlooked by the court, a similarly slight error on an objector's petition should be similarly overlooked, especially when the actual facts, the only documentation in the record is that, in fact, the objector lives, or essentially lives, in Thornton Township. With respect to the second, well, actually, the second and third, I would lump together. That's in section 2 of our response. Section 7-53 is applicable because the candidate did in fact attempt to file for the Democratic Party's nomination for the supervisor. There's no dispute that is before this board. Those papers. Just because no election is being held, did not mean that this candidate and all of his petition supporters, it does not mean that they did not circulate figures for the Democratic Party during the circulation period. Said in a more positive way. In fact, candidate and all the petition circulators circulated papers during this election cycle for the Democratic Party. And that precludes this candidate from running as an independent candidate in the general election in April. I repeat, the facts before this board show that the candidate circulated nomination papers for the Democratic Party, and the statute includes that person circulating or running or whatever you want to say. As an independent during the same election cycle, which nobody would reasonably dispute here. So therefore, then we go to the next section, section 3, which of our response, which gives additional guidance to this board. And that is that section 10.4, which governs the second election cycle. I should say the second of the same election cycle, the general election, for which any independent could run. Section 10-4 says that you may not circulate or certify petitions for candidate of more than one political party. Or for an independent candidate for one party to be voted on at the next primary general election. Or for such candidate or party with respect to the same political subdivision that's considered inside. That is exactly what we've already established. Submitted and circulated nomination papers for Democratic primary. That was not the problem of the moment. Secondly, it still violates section 10.4, which allows me independent one. And the case law that we cited there, where people were talking about ballot because they circulated for Democratic candidates who are consolidated primary, and then for an independent candidate in the general election. And that was kind of concluded by versus the municipal officers of Electoral Board of River, just a few miles from here. And Illinois is important. So, contrary to the arguments raised by the candidates council here, there's the reference law that the thing is supposed to be done, the plain language of the statute similarly does so. And what was the holding? Here we come to the Catskill, the Ellsbury line, which stands for the same proposition, fuel circulated from a prohibition, although it's like a lesson. And then as far as the Constitution goes, the attorney is absolutely correct. That this board does not have the authority to decide such matters. However, we would simply state on record that nothing herein violates the equal protection rights of this candidate, and in fact, section 10-4 is declared to not regulate speech, and not regulate that type of conduct, equal protection conduct. And so we would assert that the equal protection argument. Thank you.
Okay, thank you. And Mr.
Oh,
Otto,
wait, can I, if I have any time left? Oh, but, I won't take all that. We would ask that the motion be denied, to dismiss, and since we are arguing the merits, we would argue.
And my son was here on the last work. I was in the hospital, and I just want to make sure they were allowed to withdraw. My son did for each and every case, because I have 2 for Mr. Moore and 3 from Ms. Melvin. And I do believe somebody stepped up on my behalf. Somebody raised an issue with my son not being an attorney.
so that was actually in a different case, so we'll deal with that in a different case. Mr. Avery did not raise any such objection, and we had integrated the schedule without your physical appearance being necessary. Also, the candidate was here, so that's not an issue in this case.
Oh, I just want to make sure that I address that, so there's no, but I'll take my time.
Yeah, without taking from this time, I am both an appearance on behalf of the objector and Mr. Beal's appearance on behalf. And so, no,
Perfect, thank you.
Your Honor, the presumption is not for the objector, it's for the candidate. The candidate has a fundamental constitutional right to elect. And that's the Anderson case, that's the Social Workers Party's case, that's the Celebrity case, and many other cases that have those Mission of motion to strike and dismiss, but there's no doubt that the candidate has the fundamental rights without accessing the United States Constitution, also the 14th Amendment of the United States Constitution. And Your Honors, the objector is a creature of statute. So just because a scrivener's error by the candidate may be excused by the court does not mean the same is true for the objector. They are not on equal footing. And also, if my client on his statement of candidate, or excuse me, candidate will look for the address of the objector. If that address does not exist within the jurisdiction that's listed on the objection petition, then that objection should be stricken. I also cited Cochee versus Cook County, and which I already gave you the citation for above. Where objection petition states objection residence at an Evanston address that is not within the district which the candidate is running, the objector admits living there, he lacks standing to file the objection, and that also cites Cobb versus Calvin, 08 EP RGA 32, Chicago Electoral Board 2007. Where objector challenged the nomination papers for a candidate for board committee in the 9th Ward of the city of Chicago, listed residence address in Berlin, Illinois, he lacks the requisite residency qualifications to file the objections in that section. 10-8 of the election code requires an objector be a legal voter of the political subdivision or district which the candidate is to be voted on. Mayor's versus Holmes, 08 EBWCW 01, Chicago Electoral Board 2007. I also now shifting to the second issue, that is the issue of filing for two primaries, or excuse me, two races. There was no primary election. There was no primary election, and there was no primary election circulation period, nor primary election filing period in this jurisdiction for the office the candidate sought. There was no primary election in this jurisdiction for the office sought in 2025. The nominee petitions could not be accepted because there is no primary. There was no primary. And for that, I'd like to also cite Duffy versus Kennedy, GE 508, recommendation and board adopting recommendation to discuss sections of the objection or relied upon 7-43, and Kennedy having previously filed an FEC statement of candidacy but did not participate in the Illinois primary election. However, the state board did enforce the dual circulated position in 10-4 when there was a primary election. So the electoral boards and courts have enforced it when there is a primary election. But when there's not a primary election, they did not enforce it. So 7-43 does not apply here, and I stand on the rest of the case law and argument that I cited in my original motion to strike and dismiss. Thank you very much. I ask you to strike the objector petition and find that Cindy Moore's name be found to be on the ballot.
Okay, thank you to the parties. So at this time, I think that the first thing that the board needs to address is the standing issue. Because if there is, but I would still recommend that the board make a full record and recommendation in case, if the board decides that the objector has no standing, then the case would get dismissed. But if the objector appeals it and goes up to the circuit court, files a petition for judicial review, and that decision is overturned by either the circuit court or an appellate court, then it would come back down here. So it'd be my recommendation that if the board does determine that there's no standing, that we still proceed to the merits of the rest of the objections to have a full and complete record. Do the parties have any objection on that?
No objection, Your Honor. No objection.
Okay, so at this time, board, the first question is, does the board believe that that the objector's error as it relates to the address was a simple scrivener's error that had no legal effect, that should be considered substantial compliance, it's just a slight error and should be excused? Or does the board think that no, that's more than a slight error, and that the Pucci case, which was cited by candidates counsel, which stated, which basically had included a failure to state a complete address. It had the name of the street, I believe, or not the numbers. The address in the Pucci case was not a complete address. I think it had the name of the street and not the numbers. I'll double check that really quickly. So the name and the address of the objector, are generally important in this field, because you need to be able to determine whether the objector actually has standing to bring the objection against the candidate. For instance, there's some communities that elect their elected officials by aldermanic wards or by trustee wards. So a trustee in Ward 1 or an alderman in Ward 1 can only be objected to, or an alderman candidate in Ward 1 can only be objected to by a resident of Ward 1. Somebody from Ward 2 can't come over and object to a resident of Ward 1 because they would not have standing. So that's kind of what standing means. And what Mr. Avila is saying is that the address presented on the objector's petition, which has an additional digit per what Mr. Avery is saying, prevents the objector from having standing. So the question then becomes, do you view the error with the additional digit as something that impacts the objector's standing and the ability to bring this objection? Or do you view it as just a minor error and that the objection should proceed? So then I'm just going to read a couple things here. The failure to give a complete address, one that includes at least the name of the street of the objector's residence, can lead to the objector's petition being stricken. And that's from the Pucci versus Cook County Officers Electoral Board case. In addition to that, that's this page. Section 10-8 of the election code also states that the objector's petition shall give the objector's name and residence address, and so fully state the nature of the objection. Now, there are cases related to the fully stating the nature of the objection where the courts have actually found that just by filing the objection, you're essentially stating the nature. So the courts have sort of backed off on that specific requirement. But I don't know of any courts that have abrogated the Pucci requirement, which is with the name and address. So this, and I'm reading from a legal guide that sort of discusses the interplay between these cases. The objector functions in effect as if he or she wants, or if he or she were the plaintiff in an ordinary civil suit. The candidate whose nomination papers or certificate of nomination is objected to is in turn analogous to a defendant. Whether a given objector's petition has properly set forth the objector's name and address have both been subject to litigation. In Morton versus the State Officers Electoral Board, 311 ILAP 3rd 982, the name of the objector was found to be adequately stated for the purpose of the objector's petition, even though it did not contain the suffix junior, which was included in the name of the objector when we registered to vote. The failure to give a complete street address, one that includes at least the name and the street of the objector's residence, can lead to the objector's petition being stricken, and that's the Pucci case. The name and address of an objector are important because this information is essential to determining whether the objector is, as required, a registered voter in the appropriate jurisdiction or district. The relief requested of an electoral board almost always will be sustaining the objection and invalidation of nomination petitions. The stated interest of the objector usually he or she wishes to see the laws of the election laws upheld. The objector need not say more, or need say no more about his interest. So it goes on to talk more about the interest of the objectors, but as it relates to the address, the only case that I was really able to find that's on point with this is Pucci. And again, that one does state that failure to give a complete straight address can lead to an objector, it can lead to an objector's petition being stricken. So I think the ultimate question to the board is, does the board think that this was just a de minimis error, not really that big of a deal as it relates to the address, the numerical address that was on the objector's petition? Or does the board feel that that deprives the candidate of the ability to defend themselves and investigate the objection and determine whether the objector is in fact a registered voter?
Make motion to dismiss.
So you agree that the standing of the objector, that the objector has no standing because of the mistake in the address? Just I want to be clear with the motions, because there is a motion to dismiss pending filed by Mr. Avila. And no, so that's the motion that was filed, and part of that motion is that the objector does not have any standing. So are you ruling that the objector has no standing and to grant the motion to dismiss on the basis that the objector has no standing, or are you ruling that the objector does have standing and we should proceed forward? Okay, so yeah, I'm glad I clarified that. Okay, so the board chair is making a motion to deny the motion to dismiss as it relates to the standing of the objector. Do we have a second on that? And that would mean that the case would continue to proceed. Okay, so we have a motion and a second. Chair Gonzalez?
Yes.
Member Wells?
Yes.
And Member Gray Everett?
Yes.
Okay, so the board has ruled that the objector does have standing and that the board, that the objections can proceed. The next item is that the candidate, statement of candidacy filed for the primary election. Under the election code, under section 7-4 of the election code, candidates are prohibited from filing a statement of candidacy for a partisan office in a primary election, and then filing as an independent, or filing statement of candidacy as an independent candidate. In the Rudd versus Cook County Officers Electoral Board case, or Lake County Officers Electoral Board case rather, and the citation for that is 2016 Ill Act 2nd 160649. The Illinois Appellate Court held that a candidate who withdrew his candidacy as a Democrat was still prohibited from filing a statement of candidacy as an independent under section 7-43, despite having withdrawn his Democratic candidacy. In this case, candidate Moore filed a statement of candidacy to run as a Democrat in February 25th, 2025 primary election. Under section 7-43, Moore is prohibited from filing a statement of candidacy, at least in our opinion. Moore is prohibited from filing a statement of candidacy as an independent to run in the April 1st general election. And the reason for that is because that would be swearing under two documents. Under one saying that you are a Democrat, and then swearing a month later in another document saying you're an independent. And therefore, it is our recommendation to sustain the objections. And just wanted to address the issue of the fact that there is not actually a primary. The fact that there is not actually a primary, while that may negate the candidacy, that does not negate the act of signing an affidavit. And that's essentially what a statement of candidacy is. So it would be our my recommendation, along with my colleague, to sustain the injunction.
Motion to sustain.
Second. Okay, we have a motion by Chair Gonzalez, a second by Member Wells to sustain the objection, and then just to be clear, there'll be motion to sustain the objection and to deny the motion to strike and dismiss on that basis, right? Okay, probably should have said that, I apologize. Okay, Chair Gonzalez.
Yes.
Member Wells. Yes. Member Gray Everett. Okay, the motion to dismiss is denied on that basis, and the objection as it relates to the filing of the statement of candidacy is sustained. Okay, so next we go to the circulating of nomination petitions for multiple parties. The candidate has argued that, since there is no other election occurring, that doesn't matter. The objector has argued that, yes, it does matter and violates section 10(4) of the election code. So section 10(4) of the election code prohibits a person from being a dual circulator, i.e. from circulating petitions for an independent candidate and for a political party candidate to be voted on at the next primary or general election. Specifically, section 10-4 states that no person shall circulate or certify petitions for candidates of more than one political party or for an independent candidate or candidates in addition to one political party to be voted on at the next primary or general election, or for such candidates and parties with respect to the same political subdivision in the next consolidated election. In McCaskill, the court also analyzed the meaning of the dual circulation provisions of the election code. In that case, the candidate circulated petitions to run as a Democrat, but upon learning that there was no political primary, he circulated petitions to run as a nonpartisan candidate. The court stated that the dual circulation provision did not apply because there were no partisan candidates to be voted upon at any consolidated election for city offices in the city parliament. In Elam versus Municipal Officers Electoral Board for the Village of Riverdale, the court found that the dual circulator provision applied when the circulator circulated Democratic petitions for consolidated primary and for an independent candidate in the consolidated general election. While there will not be a Democratic primary in Thornton Township, as it currently stands, there will be a Democratic candidate for Thornton Township. If there were no Democratic primary or candidate, then there would not be any Democrats being voted upon. However, since there is a Democratic candidate on the ballot for the general consolidated election for Thornton Township, specifically for the position of supervisor, it is my opinion that I believe that the dual circulation provision in section 10-4 would in fact apply. And it would be my recommendation to sustain the objector's petition on that basis.
Motion to sustain.
And to deny the motion to dismiss. Okay. And do we have a second? Second. Thank you. Okay, now I'm going to do a roll call. Chair Gonzalez.
Yes.
Member Wells. And Member Graham. Yes. Oh, thank you, ma'am. Okay, so the objections against Mr. Moore in the case of 25 TOEB 09 have been sustained. Mr. Avo, we will be reconvening here on the 30th at 10 a.m. to give the written decision and tender it in open session. As you know, that's when you're
December 30th.
December 30th, correct. Will you be able to be here or will you waive in-person service?
I'll be able to be here also, but,
Okay.
just to pick up the,
It's just to pick up the decision. So if you change your mind and you don't feel like coming, you just want us to email you the decision, just send me notification of that and we'll go ahead and get that out. to you. Okay. Thank you. Nothing further with, that matter. And we taking, quick break. We'll be back 5 minutes, everybody. We'll have. Yes. Okay. So, yeah, one more case here. Yeah. Four more cases. One more with this one, over the other. Who wants to be able to begin? Yeah.
Hey, all right, so I'm just gonna take y'all with me. So right now, what's happening is, and I'm not sure if I'll be able to stay, you guys. So this is what's happening. Um, so the room is over here. You got Tiffany, she's over here, and Michael's here. And then you got everybody just taking a quick break. We've been here since 9:45. So it's a long day. We've been here since 9:45. Let me see. And I have to go to work myself, so I won't. Sorry, guys. Sorry. Okay. So, need some food. Yeah. So we're just gonna see. The good thing is, it's only 5 more cases. So if it's no arguments, that means 5 more cases, 10 minutes long. Okay. So there's that. There's that. So that's it. 5 more cases, 10 minutes long. So we got Felisa Melvin, that's Felisa, and Tiffany here speaking over there. And she's gonna be she's running for trustee. So I think we did all the supervisor cases. So let's hang in there. If you don't mind, thumbs up the video. It helps the channel. I'm gonna stay as long as I can. We're definitely, wait a minute, can I do my thing? Okay. Can we do it, y'all, since we got a break? Can we be, y'all know what I'm about to play, right?
Can I be recognized, Mayor?
You want to be long-winded?
So there you go. So we're playing that right now. And it's so funny because uh, I gotta play it right now. And then that's it. How you doing, trustee? Good.
Wow.
So let me see. So he's going to the South Town to do that. So let's see.
Can I be
Let's
recognized,
go
man?
ahead, play out.
You want to be long-winded? I'm just asking.
I make mistakes.
There you go. That's our little sound bite. So 5 minutes. 5 minutes. If it's no argument, we'll be out of here in 50 minutes at the longest, right? So another 50 minutes long. So thumbs up if you can. I appreciate y'all being here. And it's, yes, it's weird playing that, and Tiffany's like right in front of me, and I'm like, if she looked up, like, you gonna be long-winded? But like, I'm sure she knows we play that over here.
Yeah, well, that's, that's what it's obviously.
So now this time I am in front of my tripod. I'm just off to the side. I'm in the media section. I brought everything over here because of my little. Ooh, she has popcorn. That popcorn looks delicious. She got popcorn. You know what? Back in the day, they used to have a popcorn machine here that pop fresh popcorn. But shout out, we talking fashion right here. My girl, I don't know if you can see her. She's standing up with the black dress. Hold on, let me try to get close, baby, because we gotta talk fashion. That black dress over there, you see her with those heels and her black wrap dress and the Chanel bag. Oh my goodness, she's not playing any games with anybody, honey. She came to slay. Black tights, black pumps. She came to slay, not play. Okay. Okay. Class. So let's see how long this will be. And that's it.
Each one is different, even though they may sound the same.
Yeah, she does. Winky, please.
Yeah. They're all, even though they may say type of decisions, there's different circumstances. So you have to figure each, as you can. There, like I said, it's some of these, and as you saw, some of those attorneys, people are ways.
Since it's interesting, it's like you're honestly for right now.
Yep. Exactly.
So weird.
It is, so.
Yeah, you're allowed to make a decision.
Yeah, no, I think obviously things.
Yeah.
So that's when you gotta test it.
Yeah.
Kind of person allowed. I mean, I know.
Right. He would put like Blanchard and he had
Oh, yeah, yeah, so basically, like I said, and I saw. One thing that's good about. So, to be the boss, if I say. It's made. That's what it's. Now, if it wasn't. So that's what that's.
Okay.
I don't know. No, I got you.
All right, thanks.
I mean, when I say race through. You took a break. You didn't get to be there. Oh, you could have told me what I could do for you. Get some ladies, so you can do something. And that's the whole. You didn't miss our meeting. That is. Left. It wasn't. It was not named these. We're representing like literally. They were explaining. It was about the address. It's on my video. What is your Burgundy Blue? Bring the work. It's an activity. I love it. It's so beautiful. I was listening here. That was so good. I had to go to the water. I was. I'm not just saying. I tried to get it. Because I said, yeah,
Yeah, well, I'm sitting two of them up and still have our camera. I'm not even counting. I'm heading. So
Okay, okay, great. I think I've had 3 years. Oh, oh, it was continued. Okay, so we're over here trying to see how things are gonna go so far. Oh, wow. Well, that's why she's unbothered, I guess. So I might have to leave, but Harvey World Herald is still here to give the whole thing and see how's it going, and that's it. And that's all. Nobody, Christina. I'm the only one here. I'm trying. Wait just a second. Oh, that's a long 5 minutes, y'all. Love you, real Magnolia. Thank you. Y'all so sweet. Y'all are just like, um, yeah. Cause I mean, this could go on. This is 3 hours. This could go on until we really were here just to make sure we saw what Nate Fields was gonna do. Thank you, artists.
Oh, thank you.
You welcome. The water fountain wasn't working, so they got us some water. I'm starving too. I don't know what's gonna happen. Stephanie here too. And she gotta come back. They all gotta come back tonight. They're gonna be super tired. They all gotta come back tonight. I didn't think anyone else was challenging Nate, but now I see uh Smith and Smith and what's his name? I always forget his name. I'm not here. Keith Price. I always get. They're back up there again. They're back up there again. So, okay, Darlene's finally coming back. So we got the quorum. Jesus. Jesus. There we go. Y'all. Okay, so we got Stephanie. She gotta come back today anyway, right? Oh my goodness, that would have been amazing. That's it. Hey Stephanie, how you doing? It's good to see you. Um, it's insane that I should have asked, but I'm okay. As long as we can get out of here by dinner. The guard is like, I was like, I could have made a whole pot roast by now. Good Lord. Mm. Okay, I think they're getting settled back in, you guys. So we'll see how long it'll go. I'm trying to see. So who could they be contesting now, guys? Who could Keith and Mike be contesting? Look at this girl fashion right here. This is what I'm talking about. This is how you come through. This is how you come through. Yes, Chanel bag. This is interesting. This is very interesting. So Nate feels you. Hey Nate, good to see you. Good to see you. We rooting for you over here. You don't have it. No, thank you. You don't have anyone else contesting you yet today, right? That's it.
That's it.
Okay, good. Okay, so you got two out of. Oh, let me put you on camera if that's okay.
Sure.
Sure. Go ahead, Nate. So anyone else contesting you today?
So actually it was three different objectors today. Two of them had attorneys, and then the other one was Keith Price and Michael Smith. Now, Keith Price and Michael Smith had about five.
Okay, I'll bring you on out here with us because she's starting back up. Come on.
Okay.
I guess I'll be right there.
I'm sorry.
No.
So Keith Price and Michael Smith did end up they had like 5 objections. So I was able to go up against 4 of those objections and get them knocked off. 1 objection remained sustained, and so that's gonna have to be appealed.
Mhm.
And so I'll be going to the Cook County Electoral Board to appeal that and try to get that passed through the Cook County Electoral Board.
You did pretty good,
Thank you. The other 2 objections were attorneys, and so I went up against attorneys by myself with no attorney, and I beat them. So I beat 4 of Keith Price and then 2 attorneys. So I think I did pretty good, but I didn't do good enough. I like to have got everything passed. So still working on getting on the ballot. So just gonna do what needs to be done.
We'll see you December 30th at 10 a.m. And we just appreciate you. A lot of people in the comments saying, good job, you're fighting. We see how you was out there getting the signatures door to door.
Absolutely.
So keep on going. Don't give up.
Thank you. And if you guys can donate, please do. Any dollar helps for real. I think I will end up going to get an attorney this time because I don't know who's going to be on this board. So I hate that a lot of the attorneys are booked up and used up by these elected officials. It's hard to find one locally, but I have to at least consult with someone and then go up there and do what I got to do,
Yeah.
So it's for the people, I'm not doing this for me. I don't have a team right now. I'm literally doing this by myself. Once I'm